Not too infrequently in meeting with clients, we will be faced with a situation where a client is concerned about the state of a marriage between their son and daughter and a spouse. And inevitably, they want to know what can they do to protect that child's inheritance from becoming part of the divorce and potentially going to that child's spouse. Well, we always have to start with this idea. Remember, once your child receives your inheritance, it is theirs. So if all you do is you have an estate plan, whether it's a trust or beneficiary designations or a will or whatever happens to be, assets that are going to go directly to your child when you die are now theirs. Start with that understanding. Once it's theirs, your estate plan no longer covers what happens with those assets, which means it's possible once your child receives the inheritance, it could be subject to division in a later divorce. So start with this idea. Don't give it to them. If it's not theirs, it's not subject to a divorce that would happen. And then clients say, well, what do you mean don't give it to them? How can I not give it to them? I have to give it to them. Well, you don't. It's yours. You can do with it whatever you want to do with it. You don't have to give it to your child. But perhaps you could use a strategy where it could be available for your child, but they would not own it. For example, if you have a trust and you have assets inside your trust, you could, under the distribution provisions of your trust, rather than saying, when I die, distribute the trust out to my child or to my children, you could say, when I die, keep the assets in my trust to be used for the benefit of my child or children. Think that one through. If that's what you do, the assets do not belong to your child. Because they do not belong to your child, they are not part of their estate. They are not there to be subject to a possible future divorce from a spouse. So we always begin with the concept that says, don't give them the assets. Keep them inside your trust. Now, we can likely structure the trust to take care of your child. We can have discussions about whether the child should or should not be the trustee of the trust, and we'll have a lot of conversation about that. But the concept is keep the asset in your trust so that they don't go to your child. Now, let's say you have more than one child and you're only concerned about one. Well, distribute the estate out to the other ones that you don't have a concern about and keep the assets in the trust for the child that you have a concern about. I have even seen some trusts drafted where the trust says to the trustee, distribute the estate out to my children when I die, unless you, the trustee, at the time, believe that there are some marital issues, or perhaps a divorce action is pending or is likely going to be filed, and in that case authorize a trustee to simply hold on to the assets that would otherwise go to that child until the divorce action is finalized. So there's a lot that can be accomplished with creativity in drafting your trust agreement. So that's one possibility. Another possibility is sometimes clients don't like the idea because they say, well, let's take real estate as an example. If I keep the real estate in my trust, my child doesn't really have an ownership interest in the real estate. Maybe they won't think of it as being there. So another possible solution that might make sense, depending upon other factors, is to distribute, quite frankly, estate out to children in a manner, though, in which it is restricted. And let me give you one example. Let's say that you have real estate. And one option is to distribute the real estate outright to the child so it becomes a child's real estate. Another option might be, once we analyze everything, to create a limited liability company. And then you put the real estate inside the limited liability company. And then you distribute out interest in the limited liability company to the child or children. So rather than the child or children owning the real estate directly, they own an interest in the limited liability company that owns the real estate. That's step one. But what makes it work is to then have an operating agreement for the limited liability company. And in that operating agreement, you can restrict who can own the interest in the limited liability company. So normally what you do is you say the only ones that can own an interest in this limited liability company are my children and their descendants, which means their children, their children's children, their children's children, etc. But if you do that, those interest in the limited liability company or the interest in the limited liability company can never be owned by a spouse of your child because it is restricted. The operating agreement provides that it cannot go to a spouse of a child. It can only go to a child's children, your grandchildren, your great-grandchildren, etc. So what you've done is you've taken, in this case, real estate that otherwise would be owned by your child, that might be subject to a divorce action, and we've created restrictions on the real estate that now prevent it from ever going to a child's spouse in the instance where there is a divorce. So, putting restrictions on the distribution, and it would not have to simply be real estate. That LLC could own other assets. It could own investments. It could own bank accounts. It could own vehicles. It can own all kinds of things. And we're simply going to restrict the ownership of the LLC. Now, if you do that, some clients like that idea because now their child has some sense of ownership that they might otherwise not have if you simply keep it inside your trust. A third idea, if you're going to distribute it out of your trust and you don't want to go through the process of doing the LLC, or maybe it doesn't make sense because a lot of other issues that come about when we're creating LLCs, particularly for real estate, because we have to concern ourselves with uncapping property tax values for property tax purposes, etc. If you are going to distribute it out to the child, you need to make sure that your child understands that they need to keep it separate. They should not commingle, if you will, the asset with their spouse. They need to keep it separate. Why? Because when you look at the way divorce happens in the state of Michigan, and if a judge is ultimately called upon to divide up the estate between your child and a spouse, the idea is that marital property is going to be divided between the parties to the divorce. And essentially, marital property is any property or debts that are acquired during the marriage, which basically means from the date of the wedding until the judgment of the divorce is entered. So any property that is acquired during the marriage is marital property and is subject to the normal concept in a divorce action that marital property is going to be divided somewhat equally between the parties. However, there is a difference between marital property and separate property. Separate property generally are those assets that a party owned before they got married, or perhaps gifts that they have received during the marriage, or inheritances that they would receive during the course of the marriage, or assets that can be traced to those items. Notice I said, or assets that can be traced to those items. So if you look at the general concept of separate property, including inheritances, if the inheritance is kept separate from the spouse, meaning what? You don't go put it in a joint bank account. You don't put your spouse's name on the real estate. You don't commingle your funds. You don't let your spouse do improvements to the home. You keep it totally separate so that you can at least argue, or your child can at least argue in the divorce action, that that inheritance that they received is separate property. Even though it might have been a certain item that they received one day and they done some other things with it, they can trace it back to it being the inheritance, and they have kept it separate from their marital estate. Because generally, it is well-established law that separate property is awarded to the owner unless the non-owning spouse can meet one of two what would be considered statutory tests. One of those is if they can prove that they contributed to its acquisition, improvement, or accumulation. That's why you don't want your child to allow the spouse to make improvements to the home. Because if they've made improvements to the home that the child received from you, then the child spouse might be successful in establishing that they contributed to its improvement. So you want to keep it separate. You don't want the child to have their spouse to do anything with it. Or, alternatively, if the non-owning spouse can prove that absent a division of the separate property, the marital estate would be insufficient for his or her own suitable support. That's the whole idea that, look, if you're going to get divorced and the one spouse is going to be left destitute, but your child has significant assets because they received them from you as an inheritance, they've received it, it is theirs. And there is still some risk then that a court might determine that their spouse does not have sufficient assets for his or her suitable support, which is why I started this conversation with don't give it to them. If it's not theirs, it's not subject to their divorce. If you give it to them, can you put restrictions on it? And if you don't do any of that, make sure that your child understands the importance of keeping it separate. Suggest to them, create your own trust. take this inheritance that I'm receiving from you and put it inside that trust. You could go so far if you wanted to create that trust for your child. There's no law that says your child has to create their own trust. You could create a trust for your child. It would be their trust. You would be the creator, you'd be the grantor of the trust, but you could create a trust for the child, and then you could make a distribution from your estate into your child's own trust if you wanted to go that route. Now, understand your child's now going to likely be the trustee of that trust, going to be the beneficiary of that trust, and you've got a number of things to walk through there. But you could, if you wanted to, be the person who creates a trust, or if not, just make sure you understand with your child, look, you're receiving this inheritance. It's important that it never go to your spouse. So we are insisting that you create a trust. You could go so far as to say, and if you don't, I want you to create it now, and I want to make sure the estate goes into it. And if you don't, maybe we'll do something different with the inheritance. Create their own trust. At a minimum, do not commingle. Do not take the inheritance that they receive from you and put it into some sort of a joint investment account or joint bank account, whatever it happens to be. Keep it separate. Keep it separate from the marital estate. So at a minimum, your child will have the ability to argue, if a divorce occurred, that it is to be considered separate property, not marital property. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.